Okay. Hello, everyone. Welcome to another session of ILA Dialogues. Today, we have with us our member, Barrister Ummar Ziauddin from Pakistan. Umar Umar trained as a barrister from Lincoln Inns and has done his LLM from UC Berkeley. He assisted the Attorney General for Pakistan before taking up private practice. He's an adjunct member of faculty of KPK Judicial Academy and also lectures at a leading business school in the country at NUST. He also writes a weekly piece for English Daily, The Daily Times. So, Umar, welcome, and we're really happy to have this session with you.
Thank you so much, Sudesha, for having me on this dialogue session. Quite excited to be part of it. It's a great initiative. I think what ILA has covered in a very short span of time is tremendous. It's not just about coming together, sharing ideas and experiences to explore greater mutually beneficial opportunities, but also to think of possible solutions that our justice systems face throughout the world. At times, it does take an outsider's view to find a solution, and this is what we at ILA, in a very short span of time, are trying to explore.
True.
So I'm happy to start with uh, the topic that we selected for this particular dialogue. If you're ready, I'm happy to get
Yes,
going.
yes. Just a second. Okay. Yeah.
Right. Uh, the issue that we wanted to talk about today in Pakistani context, of course, is whether the superior courts are within their power to issue directions to enact or amend primary legislations or formulate or modify secondary legislations. This is a sensitive area for a lot of practitioners who are associated with administrative law and constitutional practice. It's true for every country that has a constitution and affords judicial review under the constitution. Before we delve into substantive part of the discussion, I just wanted to give our audiences a brief rundown of how our structure is uh, premised. So our appointments to the superior courts and to the Supreme Court, they're provided under Article 175A of the Constitution. The article itself was inserted through an 18th amendment. There have been a total of 24. There are more proposed and underway. So under Article 175A, a judicial commission nominates through a majority a person to be appointed as a justice of the superior courts, which is then confirmed by a parliamentary committee. Again, composition provided of judicial commission and parliamentary committee or commission in the constitution. And they confirm the nomination within a time period of 14 days. If they don't, it's deemed to be admitted. This present text of the Constitution, ironically, was brought about through a judicial intervention. So, a court, and I'd like to give a citation for the audience as well, while entertaining challenges to the 18th constitutional amendment in a judgment which is cited as PLD 2010, Supreme Court, page 1165, issued certain expectations, gave certain observations on the independence of judiciary in its opinion. And the present text of this article is an outcome of judicial intervention, giving directions or, you know, passing on its expectations to the lawmakers, and then the text was brought in its present form through a 19th constitutional amendment. So this sort of broadens the horizon for us. It's not just primary and secondary legislation that we're talking about in Pakistan. Judicial intervention has also sought to amend the constitution of the country as well. As it is true for any other constitutional constitutional practice. It is true for Pakistan as well. Our courts, in addition to self-restraint, are also constrained by the principles, say, of deference, comity, separation of powers. And in addition, there are other issues such as ripeness and policy or political questions that the courts take into account before exercising jurisdiction. Our high courts exercise powers of judicial review under Article 199, and our Supreme Court exercises jurisdiction under Article 184(3) of the Constitution. Um, Very briefly, again, our high courts can issue writs of mandamus, prohibition, certiorari, uh, enforcement of fundamental rights. There's quo warranto, and there is habeas corpus. And these same writs are issued by our Supreme Court as well, except that there's no requirement of a person aggrieved for one to for the Supreme Court to take cognizance of a matter in its original jurisdiction. A high courts can only act if an application is presented by a person aggrieved, and then the court takes cognizance of the issue in its original jurisdiction. These powers for the Supreme Court, they're called suo motu powers, a concept which our friends across the Suez Canal in the US, they're not really comfortable with the idea that how a Supreme Court can do all of that in its own motion, raise and settle issues. But it happens in India, I suppose it happens in Pakistan as well. So this is the general structure of how our non-elected panel, though they go through a political process, are appointed. And once they are appointed, they then can review both executive and parliamentary actions. We know, and then we generally spoke of the constraints, the general constraints. We're talking about comity, deference, separation of powers, so on and so forth. The general idea is, insofar as executive actions are concerned, yes, our courts can issue different writs that are available to the courts. And even when there is inaction, for insofar as the performance of statutory duties are concerned, the courts may issue writs of mandamus or say enforcement of fundamental rights for that statutory functionary to act. So omission there is provided for, catered for in our constitution, and our courts very aggressively, where there's an omission left by an executive functionary, fill in the gap and issue appropriate directions. What happens if there is no legislation in place, primary or secondary? Do we then expect the courts to act, fill in the gap where there's a vacuum, and give directions to formulate rules, part of secondary legislation, or even provide for an act of parliament? So this is where a lot of world are divided, and they're not really, by and large, comfortable with the idea that our superior court should give directions for lawmaking, primary or secondary. And that's the general opinion which prevails in practitioners who are associated with administrative law. When the power of judicial review was initially conceived, so we go back to Marbury and Madison, and now it's provided for expressly in different constitutions of the country. At the time, certainly the state did not quite function as it does today. A lot of problems that with time have emerged because of the complexities of how the state operates on so many levels, doing so many functions, that every conceivable position was not really envisaged at the time powers for judicial review were created. Same is true when the framers envisaged to provide for judicial review in Pakistan as well. However, there has been a recent trend, especially in Pakistan, where the courts have sort of pushed the contours of judicial review. And while exercising powers of review, they have issued directions to fill the legislative gap, whether it's primary legislation or secondary legislation. And for our audiences, I'd like to give a few citations as well, because all of these are available. So to start with, it's PLD 2020, Supreme Court 1, PLD 2019, Supreme Court 280, and PLD 2014, Supreme Court 668. It's a recent trend. It has been there, but it's sort of picked up uh, lately as well. And it's divided the legal fraternity in Pakistan. Whether or not the court should do it, is it an instance of judicial activism, or is it a display of separation of powers and judicial restraint? Depends on who is more convincing and which side of the, say, bargain you're on. The position is law is always informed by the circumstances. And it is not really, I would suggest, a wise position, especially given the circumstances today, to assert that the courts are actually overstepping their lawful bounds when they're issuing such directions. There's so many circumstances, and we can sort of break them down and pass them out into different situations where the courts can, should, and legitimately do give such directions. For instance, when the courts strike down a vires of law, the test provided in Pakistan for primary legislation is the same as it is in India, that your primary legislation, an act of parliament or a provincial assembly or a state, should not uh, trample upon individuals' fundamental rights or infringe any of the provisions of the Constitution. So, on the touchstone of this broad test, say a court strikes down a piece of legislation. While striking down a legislation or giving such declaration that it's ultra vires, the court may issue guidelines or broad parameters so as to inform the lawmakers as to what possible issues they must take into account when they are framing the new law or amending the existing law or a provision, substituting the provision struck down by the court of law. They cannot certainly dictate what that piece of legislation should be, and we'll come to that. But they can certainly issue guidelines. They can certainly issue, or in their opinions, give broad parameters as to what future legislation should be. Second instance could be a bill not taken up for hearing, and one moves the court and asks the court to give direction to the government to table the bill and formulate the law. Again, given the broad constraints that we've just identified, in this case, would the court be entering into a policy matter or into a political thicket? So here a court must do a balancing exercise. While it is within its powers to issue certain directions, fill the legislative gap, however, it must also exercise self-restraint, especially when it appears that giving such directions may put court into a political thicket or may slide the court into a policy domain of the executive or the government. So this is a question again of circumstance given the general power that they may legitimately exercise this power. So the extent of what the court can and cannot do will be informed by the circumstance, and that direction, guideline, or opinion of the court is generally also informed by the principles of separation of power. Here I'd like to read a little excerpt from the recent Supreme Court view, PLD 2020, Supreme Court 1. This again is a judgment which, without discussing the context of it, split the legal fraternity as to the direction in which the court went. However, it's nonetheless important to highlight that at times issuing directions to the parliament or executive to formulate legislation or rules, enact legislation or formulate rules, can also be an instance where the court has exercised deference and has deferred to the coordinate branches. Paragraph 47. Separation of powers is a cornerstone of constitutional democracy, and we do not wish to encroach upon the domain of the legislature. The court has, therefore, in many cases, exercised judicial restraint in deference to the principle of the trichotomy of powers and given the other branches of the government a fair opportunity to fulfill their constitutional mandate before making a final verdict on disputed matters. Cites the cases in the past, then we therefore exercise judicial restraint and give an opportunity to the federal government, in light of the assurance of the Attorney General, to carry out appropriate legislation through an act of parliament within a period of 6 months. The question that I want to strike home is this. The court did not tell what to legislate. The court only expected that the legislative cover would be provided, and the court left it to the discretion of the parliament as to what form that law would take. However, the court did do one instance where one would feel that it may be on balance activism. It specified the time frame under which or in which that legislation had to be carried out, which was 6 months. But given the practical realities and exigencies of our political system, at times time frame coming from the court is important, especially if matters are as sensitive as the one taken up before the Supreme Court in which this direction was given. To sum up what we've discussed, here's a non-elected panel of jurists in the Supreme Court, in the respective high courts. And here we are trying to argue that this non-elected panel of jurists is within its power now to issue directions to the executive and to the parliament to enact primary legislation, bring amendments to it, and or formulate, give directions to the executive, formulate rules or modify existing rules. A power which was traditionally reserved only for the elected branch of the government. However, with time, what we've learned is there's no such thing as pure separation of powers. So rule making or law making, initially a reserve for the parliament, has now been given to the executive as well. In fact, a judicial branch also formulates its own rules for its own internal management, so on and so forth, not just for the court processes, but for the administrative processes as well. So rule making is done by all three branches now. So it's no more a reserve of the elected or the elected branch only. Secondly, there might be circumstances in which giving such power of judicial review, where they can issue such directions, is an instance where separation of powers is protected and not trampled upon. Courts may strike down, exercise authority, issue writs. However, they've displayed restraint and ask the parliament or the executive to provide for a legislative cover so that the court does not have to act. Thirdly, this power will always be informed by the circumstances, and the extent of this would be that the courts, while they can issue such guidelines, must not tell executive or the parliament what to frame or what to legislate. So that should be left only to the discretion of the coordinate branches. However, general guidelines or contours, I feel, could be issued by the courts of competent jurisdiction under judicial review. Thank you.
Uh, Thank you, Umar. Does anybody have any questions?
Yes, I do. Thank you very much. This is very interesting. I'll just, my question to you is that I presume, the high courts, of course, have the jurisdiction to issue writs. But can anybody, for example, like in India, it is possible to approach the Supreme Court directly on not as in by way of what we call a special leave petition, but directly as a writ petition for enforcement of fundamental rights. Do you have that scope and power as well in
Yes.
Pakistan?
So, yes, thank you, sir. Yes, we do have that power reserved for the Supreme Court in its original jurisdiction. The test being that it has to involve a question of fundamental rights and that it should affect public at large. So you can't really raise and settle personal or issues that only concern you as an individual before the Supreme Court. They have to be questions of public importance, and secondly, they involve issues of enforcement of fundamental rights. So these are the two ingredients of a test for the exercise of original jurisdiction of the Supreme Court.
And the second part of the question is, do they also exercise sometimes power suo moto? Is that common or not so common?
Right. It is. It's okay. So here's a deal. We've had two pronounced trends in our Supreme Court where it's exercised suo motu powers very aggressively. One was under former Chief Justice Iftikhar Chaudhry, and the second one was under Chief Justice Saqib Nisar. Saqib Nisar Saab's era is roughly 2017 to 19, and Iftikhar Chaudhry Saab's era is 2007 to I think 11 or 12. So these are the trends in which the Supreme Court very aggressively exercised powers of suo motu, and it raised and settled issues on its own without anybody having to move an application before the Supreme Court.
Sir, any other question? Does anybody else have any other questions? Okay, so if considering nobody else has any type of question, Umar, thank you for sparing us your precious time to have this session of ILA Dialogues with us. Really looking forward for our next session, and if you have any other topic that you would want to talk about, we would be glad to host you.
Thank you so much for extending the invite. Thank you so much for being part of this dialogue with me. Uh, I hope I was not too boring, and I hope I was bearable. I look forward to more sessions in future as well.
Thank you.
Thank you.
Thank you so much.
Thank you.